Then good morning, everyone. I'm Rosalie Bordelev, Chief Deputy Attorney General with the Boards and Open Government Division. And my presentation today is going to give a general overview of the Nevada Open Meeting Law, or OML, as I will frequently refer to it, particularly as applied to state boards and commissions, other committees within state government. I'll also give an update on Assembly Bill 253 from the 2021 legislative session that allows most public bodies within the state of Nevada to hold entirely virtual meetings. And it takes the place of the Emergency Directive 6 that has expired. So Nevada's open meeting law is housed in NRS Chapter 241 and applies generally to all meetings of public bodies within the state of Nevada. However, as I'll mention later and go through a few of them, there are many exceptions to this general mandate. I will address a few. However, they're across the NRS. There are specific public bodies or specific functions of public bodies that have their own exceptions to the open meeting law. And if you have those or are unsure ever, it will depend on that and questions of counsel and those of you attorneys watching. You may receive questions on specific areas. There are many exceptions. Chapter 241 is the general rule, but to the extent that there are specific exceptions within any other chapter, those would control. Now, a public body is, you must meet the definition of a public body for the open meeting law to apply. And it's defined as any administrative, advisory, executive, or legislative body of state or local government consisting of at least two persons, which expends or disperses or is supported in whole or in part by tax revenue. This is fairly broad, but in most cases, especially within state government, it's usually pretty clear when we have bodies comprised of elected officials or gubernatorial appointees. These are going to be public bodies that need to comply with the law. And the definition of public body includes subcommittees created by those public bodies, even if those subcommittees only have advisory power. And so it is important to know in those situations that subcommittees will still need to. The open meeting law requires that public bodies take their actions openly and that their deliberations be conducted openly. This is the stated intent by the legislature, and it guides the interpretation of the law by both the Attorney General's office and courts. In McKay v. Board of Supervisors, the Nevada Supreme Court confirmed that the spirit and policy behind the open meeting law favors open meetings, and any exceptions thereto should be strictly construed. Generally, the open meeting law requires public bodies to conduct meetings with a public notice agenda that provides full notice and disclosure of the topics scheduled to be considered. Public bodies are a collective, meaning that action requires a vote of the whole, and individual members do not have decision-making power. The exception to that would be if a public body has expressly delegated any authority to one of its members or one of its staff members, then that decision could be taken outside. And not every decision can be delegated, but it's depending on the authorization to make the decision. There are many that can. What is a meeting? Because not every gathering of members of a public body constitutes a meeting under the OML. To have a meeting, you need a quorum together with deliberation or action. And Nevada follows a fairly strict quorum standard, which means a simple majority of the total membership of the body. Now, there are many public bodies that in the legal authority creating them have a specific quorum standard specific to them. Those quorum standards would control. But where there isn't a quorum standard specific to the public body, the simple majority rule is applied under the OML. And deliberation, even without action, you can have deliberation, which means collectively to examine, weigh, and reflect upon the reasons for or against an action. And action means a decision, commitment, or promise over a matter within the public body's jurisdiction or control. So gatherings of a quorum at a social function, at a conference, or at a training would not be a meeting so long as there is no deliberation or action. And the frequent advice that I give to public bodies that I represent is, as many of them will be part of the same profession, whether they're members of a professional licensing board, and so they frequently will see each other at professional functions. So long as they don't talk shop, it is the colloquial term that I will give them. So long as they're not talking about the business of the public body, then they aren't creating a meeting and won't be violating the open meeting law, even if a quorum of them is present at the same time. Now, a major exception, and probably the largest exception to the definition of a meeting, would be the attorney-client exception. A public body may receive advice from its attorney regarding potential or existing litigation that the public body is a party to outside of a meeting. It is a complete exception to the definition of a meeting, meaning it does not have to be noticed and it does not have to be open to the public. However, to the extent that a public body can notice these things and do it in closed session, that is entirely permissible and often recommended because it increases transparency, but it is not entirely required. And a point I want to make to that is also where a public body wants to authorize its attorney to do something, that action must occur during the public meeting. So they can receive advice, they can even discuss and to some extent deliberate within that attorney-client conference, but the actual action needs to occur during a public meeting. And this includes actions such as authorizing counsel to initiate litigation, settle a case, or file an appeal. And this interpretation was often held, though not entirely the same, by our office, but in 2018, in the Commission on Ethics of the State of Nevada v. Hansen, the Supreme Court actively held that this action must occur before the attorney takes the action. In that case, the Commission on Ethics had filed a notice of appeal. The board later ratified the attorney's decision to file the notice of appeal. But by the time the board had ratified it, the 30-day appeals period had passed, and the court determined that it was invalidated because it had not been authorized. It would have needed to be filed after being authorized and within that 30 days. Now, in response to that, in 2019, the legislature added a specific provision to the OML allowing public bodies to delegate to their chair or executive director or equivalent position the authority to make litigation decisions on behalf of the public body. This delegation needs to occur before the action occurs. It has not been tested how broad that delegation can be, and that's an area where I receive a lot of questions from counsel for public bodies. And I can't give a definitive answer. My main answer is the more specific you can make that delegation, the better. If it's litigation specific, it will be stronger. However, there are many public bodies that have made a general delegation regarding all litigation decisions to be made by their chair and attorney or executive director. And the delegation itself will always be permitted under the law. The question will be, if it's ever tested in the courts, how valid the decision of the attorney is. So most likely with that specific statutory authorization, it will be upheld. So I was a little ahead of myself on that explanation, but again, that it can be difficult to determine whether or not or how to make those decisions. And my recommendation is always, if the public body can make the decision or can make a more specific litigation delegation, such as for the authorization to settle a specific case, it's preferable. I think it would be stronger when in court, but it has not yet been tested. So some points to what a meeting is. There are ways that you could encounter a meeting without the members being physically present in the same place. As we've seen over the past year and a half with COVID, there have been such an increase in the technology available and people's familiarity with the technology of being able to use technology to have a meeting for this training, for example. That is permitted under the law, and I'll get into AB 253 if the meeting is entirely virtual. However, even partially virtual meetings where just members are virtual, but public's in place or only some members, that was permitted prior to COVID and is still. Now, even when it's not designed using meeting software to have a meeting, you can still walk into that meeting problem with using technology, such as email or text messages, telephone calls. A constructive quorum can exist when you have either serial communications, could be whether it be a chat function, emails between a quorum, discussing a member. If you reach that deliberation, discussion, even if it's not occurring all at once, even if it's occurring with emails back and forth between a quorum, that would meet the definition of a meeting. And I frequently caution staff of public bodies, as well as public body members themselves, and attorneys representing public bodies, that if you are going to be communicating, for attorneys, this only counts if you're communicating in a way that isn't privileged, it isn't providing advice, because that would fall under the exception to the meeting. To frequently send an email BCCing all the members so they don't have the ability to click reply all. That's a pitfall where we often see, and I've been CC'd on emails from staff to board members where they end up clicking reply all and discussing a topic, and I have to email all of them and ask them all to stop because I don't want them to walk accidentally into a violation. The best option then is to say, it looks like a discussion is warranted on this topic, let's put it on a future meeting. A constructive quorum can also exist when you have less than a quorum talking about an issue, but one of those members, this is best to explain by example. Say you have a 7-member body and 3 members discuss an issue on a phone call. They're less than a quorum. They wouldn't be violating the law by deliberating, discussing their opinions on an issue. However, if one of those members then hangs up and calls another member who wasn't on the first call and relays those prior opinions and lets them and says, this is what we were talking about. This is what these other members think. I would like, and what do you think? You're then reaching a quorum in that discussion, and that would then reach the point of a violation. So I definitely caution board members when talking to each other to be very, very careful. I will note, though, when this can also happen with staff members, if they are simply conferring with members, often executive directors or a city manager, will choose to have individual one-on-one meetings with each member prior to a meeting to answer their questions, find out if there is additional information or backup material they'd like for the meeting. That is permissible, again, so long as that city manager or staff member who's meeting with each person doesn't start polling them or conveying the opinions across. This is how this person wants to vote, this person wants to vote, this person wants to vote, because then you reach that collective, and it's that collective that's really where you hit problems. So on to, if you have a meeting, you need to have a meeting notice and agenda that lists the time, place, and location of the meeting, the name and contact information for a person the public body may request supporting materials from, and a business address for that person, so that there is a physical place that somebody could go obtain those materials. And the agenda needs to include a list of clear and complete statements of the topics scheduled to be considered. Any action items must clearly be denoted as for possible action. And those 3 words are in quotes in the statute. So it's very important that that statement is there for any item that the public body intends to take action on. There's no requirement that a public body ever actually take action on those items, but if they might take action, they should be denoted as for possible action. Periods of public comment need to also be listed on the agenda, and I'll discuss in a little bit what is required of those public comment periods and potential restrictions to them. A list of locations where the meeting notice is posted must be on the agenda. I will note that AB 253 made some changes to how many places that location has to be posted, which I will note. The agenda needs to be posted physically at the principal office of the public body. So it's a little different than, this is a change from 2021. In 2019, the requirement and what many public bodies are used to is the agenda had to be posted at the principal office of the public body or the location of the meeting, plus 3 separate prominent locations. But there was no requirement that public bodies use a consistent location. Many did, but there wasn't a requirement for it. So what has changed with 2021 is public bodies are no longer required to post at 3 separate prominent physical locations. They only need to post to 1 physical location, which is their principal office. If they do not have an office, for example, they're a subcommittee of a larger public body, or they don't maintain office space because they're a small enough body, they need to designate a location as that principal office, at least for purposes of posting, and so that they consistently post at the same physical location. Then they also need to post on their own website if they maintain one, and Nevada's notice website, which is notice.nv.gov. And an exception to that, if they maintain one, is if a public body desires to hold an entirely virtual meeting, they must be able to post their agenda online. If they don't maintain a website, they need to find a public body that allows them to share website, whether that be using a Facebook group that's public and posting there. But Nevada's notice website does not have the ability to post a document. And that was an area that we found some difficulty in the law, because all public bodies prior to 2021 were still required to post to Nevada's notice website. However, if the public body didn't maintain a website, their meeting would be listed in the schedule on Nevada's notice website, but Nevada's notice website doesn't have the ability to host the agenda. All they can do is link to another page where the agenda is posted. So if a public body did maintain a website to post their own agenda, Nevada's notice website couldn't post it and their agenda wouldn't be online. And we have found, there is at least one of our open meeting law opinions in existence, finding that that isn't a violation, because we can't force a public body to maintain a website, especially because at times public bodies can't afford it. And public bodies within the state of Nevada, just because they exist doesn't necessarily mean they have a lot of fun. And I just make a point of this because it was a bit of a loophole that could cause some problems. And that was closed for purposes of entirely virtual meetings. The public body must have a way to post their agenda online. All this posting must occur no later than 9 a.m. of the 3rd working day prior to the meeting. Many public bodies do it by 5 p.m. to get the posting out. The 4th working day before, 9 a.m. is the absolute deadline. If you can't post by then, our office routinely will advise to reschedule the meeting because the posting time is fairly strict. Notice also must be given to individuals who have requested notice of the meetings pursuant to 241.020 subsection 3C. Individuals can make a standing request that public bodies need to honor for agendas for their meetings. If an individual says, I would like to be sent all agendas. However, that request lapses in 6 months, and the public body does need to notify the individual that their request will lapse in 6 months with the first notice they send. And that allows public bodies to clean up their list every 6 months if they would like. And anyone who wants to continue to receive agendas will need to make a request. It is also permissible to send these agendas by email if the requester has accepted that. Though if they want it in writing, they do need to receive, the public body needs to be able to send it by physical. So clear and complete. The clear and complete standard is in the law, but has been discussed by the Nevada Supreme Court a little bit in case law. It's mostly a common sense standard. Does the agenda item give the public notice of what is going to be discussed and what action could potentially be taken, so that public members can determine based off the agenda whether or not they want to attend the meeting, make public comment, and have their voices heard. This means that a higher degree of specificity is necessary for topics of substantial public interest. And that requirement was added in Sandoval v. Board of Regents, Nevada Supreme Court case. Factors to consider when determining whether something is a higher degree of is of substantial public interest, thus requiring that higher degree of specificity, is, does this topic generate a lot of public comment? Has the public body been receiving a lot of feedback from the public, letters, questions about it? Is there media coverage? It's usually fairly easy to tell whether an item is going to be high profile, is going to have a lot of people attend, whether the public is incredibly interested. And when that occurs, the more detail that can be put in the agenda, the better. If it's going to be an expenditure of funds, a range, or a high end of the potential authorization of funds, is usually recommended. And for general agenda items, that's an area such as member comments, reports. Those can be problematic. I don't necessarily advise against having them at all. Many bodies that I represent and our office represents in general have these as standing items on their agenda, whether they be member comments, whether they be an executive director's report or other staff reports. And they can be very important items because the public body members need to be apprised of what's going on in the day-to-day affairs of the agency that they oversee. But we caution that these agenda items should be limited to almost news reports. A report that says this is what's been going on, whatever, a slight presentation where a staff member or whoever's making the report pushes out some information. There can be a little discussion on these items, but the worry is if they walk into deliberation, you have a problem because the topic being deliberated on was not agenda. So the recommendation we give is if something looks like it's getting a lot of discussion or the members really are interested in it and want to have a more in-depth discussion that could walk into deliberation, that item should be added to a future agenda and agendized in more detail so that public can be permitted to attend. Some other notes to the meeting notice and agenda is if a portion of the meeting will be closed to consider the character, alleged misconduct, or professional competence of a person, the name of that person has to be listed on the agenda. There is also some noticing requirements separately to that person that I'll mention in a bit. If the public body is going to consider whether to take administrative action regarding a person, their name must be on the agenda. This is slightly different from administrative action against, but administrative action regarding against is where we trigger other noticing requirements that some of you may be familiar with, and I'll mention. But administrative action regarding a person is a lot more broad, and the name of the individual should be on the agenda. There must be a notification that items on the agenda may be taken out of order, may be combined for consideration, and may be removed from the agenda or delayed for discussion at any time. This is an absolute requirement that that notification be there. I'm sure many of you have seen it on public notice agendas. It also means that a public body can take items out of order, combine them, or remove them from the agenda. A public body will never be in violation if they cancel a meeting or they don't take action. They remove an item. When there is an issue of clear and complete or issues regarding a single item on the agenda, we frequently advise that that item be removed. But if the rest of the agenda appears fine, just go forward with removing the item. That is fine. The combining for consideration is where you see block voting, consent calendars. That is entirely permitted under the law and may be done by the public body without violation. However, I'll note I get a lot of questions, especially recently, regarding consent calendars. The open meeting law doesn't specifically address consent calendars at all. This is the only provision saying that items may be combined for consideration that really touches on them. And they are permitted. They do not have to be denoted as a consent calendar. That adds a little transparency, a little clarity for public reading of the agenda. So I definitely don't recommend against it, having it saying that this is the consent calendar and that people don't intend to discuss. But there is absolutely nothing wrong with public body members to pull items off the consent calendar because they would like to discuss them. Or if things are not listed on a consent calendar, from combining those items and taking them into block vote. So the fact that they're listed as a consent calendar, I've seen this on complaints recently. I've also been receiving questions from public body members. The fact that they're listed as that does not change change how they're treated under the law with respect to them being. And I'll also note any restrictions on comments by the general public need to be listed on the agenda. What I'll discuss in a bit what those restrictions can be, but to the extent that there's time limits or things of the sort, those need to be listed on the agenda. Public bodies are also required to make reasonable efforts to assist and accommodate persons with physical disabilities desiring to attend their meeting. When it comes to notice, the additional notice is required when you're going to consider somebody's character, competence, physical or mental health. They need to receive notice that you may discuss this. 5 days if it's by personal service, or 21 days, 21 working days. I need to add that into this slide. It is 21 working days if it's by certified mail. This does not apply to passing remarks. This is really just if you're going to discuss their qualifications for an employment position. If actually, there may be there's an exception for that one, but discussing for licensure, their qualifications, discussing whether or not maybe to remove their license. These are areas where you're going to discuss their character, maybe their potential misconduct. They need to receive specific notice of this so that they have the opportunity to prepare and be represented if they so choose. Emergency meetings. This is an area that normally was rarely touched until about a year and a half ago. An emergency meeting may only be called where the need to act upon a matter is truly unforeseen and the circumstances dictate that immediate action is required. Usually I advised against emergency meetings in the past until COVID hit, and then true circumstances existed in a lot of areas where public bodies needed to take immediate action. If there are circumstances that are unforeseen and a public body needs to take immediate action, they need to comply with as many requirements of the open meeting law as they can for their meeting. Usually they can comply with everything but the 3 working day notice. That is usually the area where a public body doesn't have time. They can gather an agenda together, they can open it to the public, but they can't post 3 days because they need to act now. And that can be permissible under the emergency provision. Now, the emergency provision and this emergency meeting only will apply to those items that must be acted on because of the emergency. So a public body can't say, we have this one emergency item, but hey, we're all together for meeting. Let's do a whole bunch of regular business. That regular business needs to be saved for when it can be adequately noticed. But if the public body said, we need to do a meeting on 24 hours notice to allow for to allow for us to take action, I'm sure you can think of many situations during COVID where that occurred. They can take they need to still take public comment, issue an agenda, even if it's only on 24 hours notice. If the public is there, take that public comment, hold the meeting like they would a normal meeting. But they can only take action on those items that are truly necessary. So some more requirements. These aren't specific to the agenda, but to the meeting. 1 copy of the agenda plus any supporting materials, the recording of the meeting. These all need to be able to be provided at no cost to a member of the public who requests them. And at least 1 copy of the supporting materials must be available at the meeting if the meeting has a physical location. If the meeting does not have a physical location because it's an entirely virtual meeting, then the public body needs to be able to post that supporting material online so it's available to the public there. It must be available through these methods at the same time that it's been provided to members of the public body. So if an item is provided to public body members only an hour before the meeting, then it only needs to be available to the public an hour before the meeting. Even if staff members may have had this document for a week. If the public body members haven't received it yet, it doesn't meet the definition of supporting material. And that's an area that has also become an issue recently with entirely virtual meetings, is when does the material need to be posted online? And the advice that I have been giving is when the material meets the definition of supporting material, which was added in 2019 to the law, then it needs to be posted online at that time, which means it does not, the definition of supporting material includes material that has been material that a reasonable public body member would rely on in making their decision on an item on a posted agenda. So if the agenda hasn't been posted yet, it doesn't actually meet that supporting material definition. It doesn't mean it's not a public record. It doesn't mean that under the public records law, a member of the public couldn't get that document a different way. But it doesn't meet the definition of supporting material under the OML until that agenda has been posted. So to the extent that there is a board book that is going out to all board members, if it's going out before the agenda is posted, then it needs to be available online for a virtual meeting or otherwise available to the public at the point that agenda is posted. However, I frequently get complaints that supporting material wasn't posted with the agenda. If the board books didn't go out to the board members until the day before the meeting, then that's when it needs to be posted and available to the public. So it is not strict for that agenda time, but if it hasn't been provided to members of the public, it still hasn't met that supporting material definition. So that's a little bit of a nuanced area, but it's an area that's become an issue more recently, especially with virtual meetings. So meetings also must be recorded, audio recorded, or transcribed. Most public bodies just keep an audio recording of their meeting that can be given to a public body member if requested, but there has to be some recording, and that recording also has to be available to the Attorney General's office if we get a complaint request. Minutes also must be kept in conformance with 241.035. Those requirements include the date and time and place of the meeting, the members in attendance, the substance of all matters proposed, discussed, or decided, and the substance of remarks made by a member of the public, or their written remarks if requested. What that means is if a member of the public appears for public comment and makes public comment, but they had prepared written remarks, they may request that those written remarks be attached to the minutes. This is different if a public body members are never required to accept written public comment. They are required to take live public comment in both virtual and physical meetings. That was not always the case during Directive 6, but that is the case as the law stands today. However, many public bodies do take written public comment. I recommend it. Additional public comment options are always recommended by our office just because it allows for additional public participation, which we like to see. But the minimum requirement is that live public comment, and if somebody does make live public comment and request their written remarks be attached to the agenda, a copy of their remarks, those need to be attached. So closed sessions, and that's some exceptions, I guess, to the openness. There are certain areas where closed sessions may be held. Public bodies, as with other exceptions to meetings, some public bodies have specific statutes allowing them to do certain portions of their meeting in closed session. Absent any of those statutes, the OML specifically allows for it when a public body is considering the character, alleged misconduct, professional competence, or the physical or mental health of a person. There's some exceptions to that, but also if they're preparing, revising, administering, or grading examinations, as many of our professional licensing boards also oversee testing for that profession. These are areas where they can go into closed session. Closed session is different from an attorney-client session in that a closed session is still part of the public meeting. It still needs to be recorded. However, that portion of the recording is not available to the public in the same way. It has some more confidentiality protection under the law, but it is, it's essentially, the closed session needs to be inside the meeting. So the meeting needs to be open to the public comment taken, and then at some point on the agenda, certain items that when you hit those, a public body member can make a motion to go into closed session. The public body can ask the public to leave. They can discuss this item and then bring the public back when they're ready to go back into open session. When it comes to decisions regarding the character, alleged misconduct, and professional competence of the person, the actual decision, the action, needs to still happen during the public portion of the meeting. But to the extent that they would like to have a discussion regarding, like you said, the character and some of those more sensitive topics, those discussions and receiving that information happen during closed session. Now, some exceptions to the exception. A closed session may not be held to discuss the appointment of any person to public office or as a member of the public body. It also cannot be held to discuss the character, alleged misconduct, or professional competence of an elected member of a public body or a person who is an appointed public officer serving at the pleasure of the public body as their chief executive or administrative officer. So where this applies to state boards and commissions primarily is their executive director, executive secretary, the equivalent head of agency position, is usually hired directly by the public body, the board. And the board then delegates to them the ability to hire and fire the remaining staff. But that one position has to be, the interview process, the performance reviews all have to occur during open public. And that can be difficult. I encourage discussing with council ways to work on doing performance reviews of chief executives. It's necessary, but it is a delicate situation frequently and can be difficult, but it is required specifically in the law. So public comment. Restrictions on public comment must be reasonable time, place, and manner restrictions. I didn't mention before, but there are two options for how a public body may take public comment. The most commonly used option is having two public comment periods during the meeting. One at the beginning of the meeting before any action is taken, and one at the end of the meeting prior to adjournment. And this would meet minimum requirements. That first, some public bodies choose to limit the first public comment period to comment on items on the agenda, and that is permissible. The second public comment option is, instead of taking that first public comment period, the public body can choose to take public comment on each action item after the matter has been discussed by the public body, but before the public body has taken a vote. This one is less common because it requires numerous public comment periods, but is permissible. Either way, the public body needs to take a public comment period prior to adjournment that allows the public to comment on anything within the public body's jurisdiction and control, regardless of whether that whether what they're commenting on is on the agenda. Now, there is nothing that prevents public bodies from taking additional public comment during the meeting. So they could take that first public comment period on items on the agenda, but I frequently see when there is a very controversial topic coming later on the agenda that the public body says, at this first period, let's comment on everything except item number 6, because we know we're going to have a lot on the 6 and we'll take it when we hear that item. So members make that public comment and they go to item 6 and they say, let's take another public comment period here. Everybody on item 6, make your comments. So that's permissible too. It's also permissible to have that first one, that last one, where you let everybody who you want to speak and still take some on individual items if it looks like there's people who want to speak. There's nothing ever prohibiting a public body from taking additional comment. We often recommend it. I love to see. Now, restrictions on the public comment period. They need to be viewpoint. That's the biggest area that we see complaints and issues regarding public comment, is they cannot be halted based on the viewpoint of the speaker, or a simple belief that defamation is occurring, or just because it's critical of a public official. This is the public's opportunity to rant and express their displeasure with the board if that's what they want to do. However, they are not protected from making threats or other speech that could be considered criminal speech. The open meeting law does not broaden any of those rights. It creates a limited public forum under the Constitution. Free speech protections apply, but there are limits to the presiding officer may also halt comments that become unduly repetitive or stray from the scope of the specified agenda topic for which the comment is offered. They also can ask that public comment members don't talk about something that's completely unrelated to the public body. If it's not within the public body's jurisdiction and control, it can be limited. That being said, the usual recommendation that I give to public bodies that I represent is to simply put a time limit and let members speak on what they'd like to speak, whether it be angry, obviously not permitting threats or some of that type of speech, but if they want whatever they want to say, let them have their 3 minutes or their 5 minutes and let them express their thoughts, because that's really what the public comment period is. I will note, though, the OML does not prevent the removal of any person who willfully disrupts a meeting to the extent that its orderly conduct is made impractical. So that is the standard for if the chair of a public body would like to remove someone. It needs to be because they are disrupting the meeting to the extent that its orderly conduct is made impractical. And I repeat that a couple times here. I give that exact language to my chairs to think about and to say if that's why they want to remove. That doesn't mean I haven't seen chairs remove people, and it is permissible. Public comment periods are when they are permitted to speak. If if public members are repeatedly interrupting the meeting, they can be removed, and that is permissible under the law. So violations. Actions taken in violation of the OML. Now, if an individual or the Attorney General's office wants to have an action declared void, they have 60 days from the alleged violation to file an action in court and have that. The individuals have the ability, individuals whose rights have been affected have the ability to file that action on their own. The Attorney General's office also has statutory enforcement powers under the OML and the authority to investigate and prosecute violations. When a violation of the OML occurs or is alleged, our office recommends that a public body make every effort to promptly correct the apparent violation. Even if the public body does not believe that they violated, if they redo the action in a way that they know they haven't violated, they can rely on the new action. Whether or not something is filed to void the prior action, the new action will stand, so the public body can move forward. And that is the main purpose for taking that corrective action. And to the extent that the Attorney General's office adjudicates complaints, which we have the authority to do, if we see that corrective action has been taken, we're not going to file that action in court to have something voided because it's honestly because it's moot at that point. It doesn't mean we won't still investigate and issue an opinion as to whether or not the violation has occurred, but it does mean you won't be defending something in court, at least from our office. So corrective action, though, does require that the public body engage in an independent deliberative action in full compliance with the OML. So to give an example of what that means is a public body holds a meeting where they they take action on something, and after the fact, somebody from the public that alleges that they were prevented from attending the meeting or because the door to the building was locked. And the public body re-agendizes, as we're going to redo this. They learned that all public was locked out of this meeting. Even though they held their whole meeting, they discussed everything. That subsequent meeting where they're taking corrective action, they need to re-discuss everything. Because the open meeting law, it has, as it's been interpreted, both in how it's stated and how it's been interpreted by the courts, it's not just the action that's required to be public, but the deliberative process. The legislature has deemed that the public's entitled to see the deliberative process of public bodies conducting the people's business in Nevada. So that means they cannot simply ratify their prior decision, saying, oh, I think we had a mistake. Well, let's vote to say that decision. We're retaking the vote. We still want to make it happen. They need to redo the deliberative process in full compliance with the OML for that corrective actions. They also need to denote it on the agenda as for possible corrective action. And I'll note a little of the Attorney General's process because that's also some frequent questions we get. If a complaint's filed with our office alleging a violation of the open meeting, it gets an initial review to see that it states a claim. If it does state a claim, we are required to notify the public body within 2 weeks that we have received the complaint and what the content of the complaint is. Open meeting law complaints are public records under the law. So we often will send that to the public body so that they can see it. However, if we're requesting, the public body only needs to respond if we request a response. If we are going to open an investigation to determine whether or not a violation has occurred, we will request a response from the public body. After receiving that response, the Deputy Attorney General who is conducting the investigation will determine if any other information is needed, whether they need to talk with witnesses. That is most common in situations of alleged secret meetings or serial communications, because there isn't a video of a meeting we can watch, or a recording of a meeting we can listen to. But we will gather additional information if it's needed. The standard is a preponderance of the evidence. And then if we determine that a violation has occurred, if we're within the 60 days, frequently complaints aren't filed until the 60 days has run or has almost run, and there's not a lot we can do. If we're within the 60 days and we determine it's necessary, which is rare, we will file in court to have an action voided. If it's not within the 60 days or we determine that it is not necessary to file an action in court, we will simply issue a findings of fact and conclusions of law. If we find that no violation has occurred, we will issue a no violation letter. Either way, both the complaining party and the public body will receive it. So technology. This is where AB 253 comes in. Prior to COVID, it was permissible to use technology for meeting, but a physical location was always required where the public was permitted to attend and participate. And Directive 6 then provided for entirely virtual meetings and took away those physical requirements. It expired on June 30th. AB 253 went into effect on July 1st. And AB 253 allows for most public bodies to hold entirely virtual meetings. The exception is for entirely elected public bodies. And this is where every single member of the public body is required to be an elected official. For most state government public bodies, they're comprised of appointees by the governor, which means they are not elected officials and they can't have entirely virtual meetings. There are exceptions to that. The Board of Prison Commissioners, the Board of Examiners are comprised of the governor and the Secretary of State, the Attorney General, at times other elected officials, which means they cannot. City councils, county commissions, they're almost always elected. Same with school boards, and they're required to have a physical location. That does not mean that members can't attend virtually. It doesn't mean public can't attend virtually. I see many hybrid meetings going on where there is a physical location where public is permitted to attend and make public comment, but there are virtual options also given. I like to see those hybrid meetings the most because it allows for the most flexibility and the most public participation, especially in today's circumstances. However, if you are permitted and are going to hold an entirely virtual meeting, go wide. If there's no physical location, the agenda and supporting materials must be posted to the public body's website. And as I said, if the public body doesn't maintain a website, they have to find basically whether it be shared. I know often the Attorney General's office has some various committees. We use the Attorney General's website. They don't need absolute independent websites, but you do need to be able to have a reasonably easy to find location where supporting material and the agenda can be posted. Information on virtual access to the meeting must be on the agenda. So instead of the physical location listed, teleconferencing information. There also has to be a phone number, a call-in phone number for the public. The entire meeting could be by phone, but if there is a video option for members, then the public needs to be able to observe the same thing that members can observe. In addition, the public also needs to have a call-in number available, and that is to provide for public who do not have internet access. they can call into and be able to at least listen to meetings. But if it's a meeting via Zoom, there needs to be a way that the public can observe. There also has to be a way for live public comment. One thing I have seen that AB 253 is new and hasn't been tested in courts. I will note that. But one thing I've seen that I view as permissible is meetings where I know this function is frequently allowed via Zoom. I'm guessing, I think it's allowed via LifeSize and probably WebEx and some of the other virtual platforms as well. The meeting is broadcast live via YouTube or another streaming service, and public body members are the only ones able to participate via video. However, the public can view the meeting. They can see what those public body members can see, and view that on the streaming service, and then public members can call in. They are able to make public comment via telephone. They can listen via telephone, or they can observe via, like I said, the streaming service. And I've seen that happen frequently. Depending on the size of the public body, you can also allow public into the Zoom. It just depends upon the size and technology. There's many ways. One pitfall, and I've gotten a lot of questions on this in the past, has to do with chat functions. They are not a per se violation of the law, but my recommendation is usually against using it, because chat functions are hard to record. If a public body is going to allow it, it needs to be available to the public so the public can see what's going on to the same level as members. Members are chatting in the chat function. That's quorum and could be deliberation, and that's meeting activity. The public not only needs to be able to see it in real time, but there also needs to be a record of it. So the chat needs to be reported by the public body in some way. And there's a lot of ways that it can cause problems. And so my usual recommendation is just turn off or don't use the chat functions and just use the video and or audio. There's also a requirement under AB 253 that the public body reasonably ensure that any person who is not a member but is otherwise required or allowed to participate, such as they have a hearing regarding their license, they need to be able to participate in their portion. That could include just making sure that they're sent a link, specifically that you don't need to be their tech support. There was a lot of discussions when this was going through about what that would entail. It's a reasonableness standards. Giving a link would be sufficient. You do not have to be, but if they call you and they say, I can't do this because of this, can you give me the phone number, whatever, there needs to be some reasonable. Some additional points in general. Parliamentary procedure is not addressed in the OML. A lot of public bodies choose to use Robert's Rules of Order. That is entirely permissible, but not required under the OML. The only thing required there is that action requires a majority vote. But the duties of the presiding officer, such as recognizing speakers, how motions are made, those are not addressed specifically in the OML. I'll also make a note from the ethics law, disclosure. If a public body member is going to make a disclosure or abstain, they need to do that prior to the consideration of the topic. To the extent that you're an attorney watching this who advises public bodies, NRS 281A.420 is the primary area that comes in. We don't have an ethics training today, but when these videos go up on our website, there will be an ethics video and ethics training available with them. That is the area to look at with deciding when members need to abstain. If a member is abstaining because of the ethics law, the number required for a quorum is reduced, and that is in that 281A.420 provision, and can give some ability to continue to hold a meeting when you are missing members due to abstentions. And let me open up for questions. There we go.
Hi,
Does anyone have any questions?
Yeah, we got some while you're presenting. So first, we have a question about subcommittees. The question is, there hasn't been a subcommittee meeting for some time, and the subcommittee is going to reconvene. However, the members of that subcommittee have changed. Out of the current subcommittee members, only one remains who was at the prior meeting. Is it possible to place the meeting minutes for approval on the agenda, or how would you recommend handling approval of those minutes when the subcommittee members have changed substantially?
Yes, it's permissible to put those on the agenda. This question comes up frequently enough. There is nothing saying that a board member who wasn't at a meeting can't vote to approve minutes. The action to approve minutes is simply saying these are going to be the official minutes that we provide. These are the official minutes of that meeting. If board members, I always let them know if they weren't there and they would like to make a disclosure that they weren't present at the meeting and they can't speak to the specific content, but they trust staff in creating it, they can do that. That isn't required, but there's nothing saying that they can't vote.
Okay, awesome. Thank you. And the next question is, did you state that a consent agenda item may be moved to the regular agenda and discussed by the board members at the same meeting, or did I misunderstand you? What if the board staff informs potential licensee that he or she does not have to appear for the consent agenda item? Is it better to table that and discuss at the next board meeting?
For purposes of if it's a hearing and other due process concerns, it would depend on the specifics of that agenda item. So I would say under the OML, there is nothing wrong with moving it to discuss. Essentially, moving it from the consent agenda is simply saying, we put on the agenda that we maybe weren't going to talk about it, but there's nothing saying you can't know that something's on the agenda and the board will not talk about it. However, many of my boards, and especially, like I said, if it's a hearing and there may be due process concerns, I'll often recommend that they table it for another meeting because they may want to get input. It kind of depends also the content of the discussion they're going to have. A lot of times if an item's pulled, it's because they have questions, and then if the person whose agenda item it is isn't there, they can't get their questions answered. So again, there could be other concerns, but under the OML, you can discuss an item that's on the.
Okay, awesome. And then there's another question we have. So we're still doing question and answer, so please feel free to put your questions in the chat if you have them. I've had the experience of boards appointing a working group to get something done and report back to the board. Is there really a difference between a working group and a subcommittee?
In most circumstances, no. It to fit the subcommittee definition, which is in 241.015, I believe it's subsection 4, which you can look at specifically, but the subcommittee definition is a little broad, and it says a subcommittee needs to be comprised of a majority of the members of the public body or staff members, or they're authorized to make a recommendation. And it's that or authorized to make a recommendation that can be problematic. So if the working group is created specifically for that purpose, it is most likely a subcommittee.
Gotcha. And we did have questions asking if now is a good time for you to share your code for the session.
Code, yes. The word is lemon.
L-E-M-O-N?
L-E-M-O-N.
All right, lemon. So the code is lemon, L-E-M-O-N. And then another question that we had was, you mentioned attaching public comments that were written to materials. What do you foresee, like if boards are struggling with the new recorded public comment, like if the file sizes are really large, we've been asked, should they transcribe that live comment? And there's an ADA component there too, right? Because people would have to be able to review that recorded comments. Do you have any recommendations on how to handle, say, a really large video file that someone then gets attached to a meeting?
So I guess I haven't seen that one before in terms of it being attached. To the extent that they made their comment live at the meeting, it's part of the meeting recording. And so it's required to be part of the meeting recording, but you don't have to separately attach it. In terms of them sending in a video as their public comment, it's permissible to do, but public bodies aren't required to accept a video sent in as public. Now, again, any restrictions need to be viewpoint neutral. So if they tell people we're accepting videos and then only accept some of them, you might have a problem there. But video comments sent in, that isn't something I've seen before in terms of attaching to the minutes. If you are accepting them, probably you don't even need to transcribe them word for word. You could simply say, put the substance in the minutes as you would other public comment. The requirement in the law to attach to minutes has to do with somebody who comes up and makes public comment at the meeting and has prepared written remarks, essentially a written version of what they said. That doesn't necessarily mean they can walk up, make public comment, and say, here's 20 pages of things I want you to attach. That is, it's written remarks is what the law says.
No, that's really helpful. And then we also got a comment, lemon, like my car. So we've got someone in the audience who appreciates the code word. So it is 10:58. If there aren't any further questions, we can wait a moment and see if there are any further ones. But this session officially ends at 11 a.m. and then there will be a 15-minute break. So we'll just wait a second and see if there are any other questions about open meeting law. I was just going to throw it. I appreciate the distinction between being able to see what the members can see, because definitely there was a lot of consternation about people having to leave cameras on so that the public could view them viewing the meeting. So that is a question that I have received at times about leaving cameras on. The requirement in the law is that the public can see what the members can see. So if a member simply has their camera off, there's no requirement that they be on camera, just because they could be judging telephonically, and that would be permitted as well. But I guess an example, a slightly different, I'll put, this is my first time using Teams in this way, to the extent that presenters can see each other. If they were given in that way, presenters can see each other, but the public isn't able to see because it's not in the broadcast. That could be problematic. I've also found had requests of boards at times that the members of the public body be present together in a physical location, but it be an entirely virtual meeting. And that I see as incredibly problematic as well, because you would have to then have all members on camera at all times and all visible to the public at the same time, and you'd still have allegations that something could happen during a break. I see it as being very problematic. It is not necessarily barred under the law straight out, but there are a lot of areas, like with the chat functions, where you could walk into violation. Thank you so much. Well, we are at 11 o'clock, so folks, feel free to take a 15-minute break, and then we will reconvene exactly at 11:15 with the Nevada Public Records Act, and that will go from 11:15 to 12:15, after which there will be the lunch hour. Leslie, did you have any comments or anything about the break or heading into the break?
No, I think that's it. We'll see everyone in 15 minutes.